why does probate have such a bad name if that's all there is to it? Well, it depends again on the state. In California, as I understand it, the legal fees are going to be dependent on the size of the estate, a percentage. That is not how it's done in Washington or in Idaho. The legal fees are going to be dependent on how much work did the lawyer need to put in to assist the personal representative in doing their job and properly administering the estate. In some cases, it can be very small. And when I'm talking legal fees and I'm talking small, keep in mind legal fees are typically more expensive than, other fees that you pay, but you're making sure you get it done right. So the legal fees could be $2,000, $3,000, $5,000, even $10,000 or above, depending on how complicated the estate was. That's why sometimes people say, oh, I just want to do it myself. That's why we have a do-it-yourself ebook that we'll provide to you. Just be aware that if you do it yourself and you don't do it right, you have assumed all of the liability for missteps, which means rather than you paying the attorney to help you, to protect you, to do your job right, you now are at risk of paying any creditors' claims or taxes or paying back anything, that wasn't done correctly. That's one of the reasons that we do recommend in a probate that you do get legal assistance. That's what a probate is. So why are probates have such a bad name? Because when we hear of a probate, we hear of the one that is totally gone wrong, that the beneficiaries are lawyered up each and fighting each other, that the will may have had some undue influence and it was maybe drafted by the decedent in the final stages of their life and a lawyer wasn't involved. Or very commonly, the person didn't have a will. So things are very confusing when there's not a will. And there are laws to say where do the assets go when there's not a will, but I can tell you it's far more complicated because you have to decide, well, what kind of asset was it? Community property, separate property, who gets what. Oftentimes, keep this in mind when you're hearing a story about a really difficult probate, I would say more often than not, you are dealing with no will or a huge estate, maybe where there wasn't a will, or very bad estate planning and dynamics. But for most people, a probate is not going to be that nightmare scenario. One of the things that I will say is that sometimes people say, well, I hear that in a probate, everybody's going to find out everything about me, my life, my family, my money. No, what's going to happen is the will be filed with a court. And yes, the will says who you are, whether you're married or single, and whether or not you have children. So they'll know your family. The will shouldn't say anything about how big your estate is. In the probate, I said we gather up the assets and we do an inventory, but we don't file anything with the court about the size of the estate or the inventory unless we have to. Why would we have to? Because a beneficiary demands it or demands an accounting, or a creditor demands that the inventory be filed because we rejected their creditor claim. So there are some situations, very uncommon, at least in our practice, where an inventory is ever filed with the court. Why I'm explaining that is that means, looking at the probate matter filed at the courthouse doesn't say anything about what the assets are. Typically, what we put in our pleadings to start the probate is that assets exceed debts by $10,000 to show the court is solvent. So that is what a probate is. I guess I went into a little bit more detail, so not in a nutshell. That's a pretty accurate description of a probate. So probate in of itself is not a horrible thing. It's not a good thing. That kind of begs the question. Remember, part of what we're talking about today is with the right estate plan. So really the key question is not, is a probate a good thing or a bad thing? The real question is, what's the right estate plan for you?